Tonight we have a few interesting subjects to cover. The details of the 25th of May 189 invitation round. Is the system broken as Clare O'Neil says, or is it just poor management? An overseas perspective on the 191 visa lack of information. Andrew Giles strives to fix the temporary worker exploitation with new rules ahead. And media complaints that the system is too complex. But is it really? Hi, I'm Carl Conrad and welcome to our weekly edition of Australian Immigration News, proudly brought to you by Australian Immigration Law Services right here in Sydney. And first up, a celebration is in order, for we have hit the 70,000 subscriber mark. Thanks to all of you who have supported this channel to make that happen. Let's see how close we get to 100,000 mark by the end of this year. The Immigration Department has been quick to release the details of the 25th of May 189 and 491 family-sponsored visas invitation round. 7,353 invitations were sent out, which is an odd number. It is either all the places they had left of the quota to send out, or rather the remaining EOIs of the occupations they wanted. My guess it is the latter. Just 74 invitations were given for the 49 family-sponsored stream. As we mentioned in the previous edition, the occupations invited were predominantly medical and allied health. We can see, however, there were 4 non-health related occupations, such as childcare centre manager, early childhood teacher, secondary school teacher, and teacher of the hearing impaired. The pass mark required for an invitation was down to the bare minimum, just 65 points. And will there be another invitation round this month? Possibly, but again we suspect if it does happen, it will be for a similar range of occupations. One of our viewers' comments last week highlighted that the 189 allocations figure of 30,375 for their next financial year should not be given to New Zealand citizens, since they will no longer need it from July. Chapella kindly pointed out that in reality, without the New Zealanders hogging all the 189 visa quota, this will provide a huge boost to other nationals hoping for an invitation. Thanks Chapella for providing that comment and reminding us all. We have heard so many times from the Home Affairs Minister Clare O'Neil that the immigration visa system is broken.
But what matters most is what this system is doing for our country. At the moment, it is broken and our government is planning to fix it.
But is the system really broken? Many visa grants are issued in less than a day now. Recently, we had an occupational trainee visa granted in just 2 hours. So for a broken system, that is pretty impressive. Isn't it really about putting in the resources to the right place to get things done, rather than blaming it on the system for the delays? It can't be too complex when visas can be granted so quickly. What really bugs us is that this allocation of time and resources is very lopsided right now. The Minister Andrew Giles has the time to jet over to Western Australia with his entourage and announce the super quick aged care industry agreement. However, after more than 4 years, his department can't even fix the information required for people to know if they meet the 191 visa requirements or not. So what is actually going on, Minister? Why has it taken more than 4 years for the department to provide this vital information? Why are you keeping the public in the dark?
You want answers? I think I'm entitled. You want answers?
I want the truth!
You can't handle the truth!
I beg to differ. I think we can all handle the truth. In fact, there are so many people out there desperate for the truth so they can make very important decisions about their futures. Tonight we speak with Colin, who lives on the other side of the world in Belarus, who is looking to apply for the 491 visa soon. Like many potential 491 visa applicants, along with 491 visa holders, and even those who have lodged their 191 applications already, he is baffled by the Immigration Department's lack of information about what is the salary he needs to get PR. The 491 visa only lasts for 5 years, but to get PR later, they need 3 tax returns in Australia. It takes a lot of planning and effort to get everything just right. This announcement of raising the TSMT to 70,000 only confused everyone because the department said the minimum income required to lodge the 191 visa was the same as the TSMT. I made contact with Colin after he left a comment on our YouTube channel. Colin, thanks for joining us tonight. How are you feeling about all this TSMT talk, and will it or won't it affect your future plans to come to Australia?
So I'm very baffled as
like many people around the world. What to do next? So, and it's already June. New financial year starts in July, and still no clarification. So how is it possible to plan your future? Am I supposed to have many contingency plans?
Yes, indeed. That is the problem with this lack of critical information. It creates uncertainty and worry. One of the real concerns is, what if they raise the minimum income level required to be able to lodge for PR? What effect do you see it would have on you?
So if you come to Australia with a 491 visa, and the first thing that you're going to do is to find a job in your field. If you don't find it, then you have to find another job, whatever it is. And this job may not satisfy your TSMIT requirements. Then you have to find another job, the second one, and have two jobs at the same time. You'll be extremely stressed out. Is this the life we want to proceed in Australia? So I don't think so.
Yes, you're right, of course. Even now, we're hearing reports of people having to work two jobs just to meet the $53,900 figure. If it goes higher to $70,000, then many more will be facing a two-job scenario. Do you think there's an argument to abolish the TSMIT level income requirement altogether?
Regional Australia is extremely diverse. It can be Perth and Adelaide, it can be Dubbo, Orange or Broome. So job opportunities in Perth and Adelaide are much better, and the salaries are much higher than in Dubbo. And why we have only one TSMIT for these regions? Then we have to have many TSMITs. And then wouldn't it be easier to abolish the TSMIT for 491 visa holders completely then?
Yes, why is it even necessary to set a minimum income figure at all? At the very least, they should abolish the perceived connection of the 191 visa to the TSMIT. It is the only logical outcome, but why can't the minister just come out and make a decision and let us all know? Yes, we are fed up, Minister, and it's time for the truth. Thanks so much, Colin, for joining us on the program tonight. It's great to obtain a fresh perspective from someone who has yet to move to Australia. In the coming weeks, Immigration Minister Andrew Giles will introduce legislation into the Parliament called the Migration Amendment Strengthening Employer Compliance Bill of 2023. The announcement was given in a speech he made at the Victoria Trades Hall on Monday the 5th of June. The proposed bill will ensure it will be a criminal offence to coerce someone into breaching their visa conditions. It will also be a criminal offence to use a worker's visa status to accept exploitation conditions in the workplace. Mr. Giles said in his speech, the Australia Border Force will be out there enforcing the law. Businesses who do the wrong thing should be ready for a knock at the door. New prohibition notices will be introduced to prevent employers and individuals from further hiring people on temporary visas where they have exploited migrants. A very tough stance indeed. And it seems the minister does watch our program and takes notice. Many of you will remember what I said about the way of solving worker exploitation in our news edition on the 28th of May. It's my opinion that visa holders who are brave enough to speak out and report dodgy employers should be offered a new work visa for at least 12 to 24 months so they can find new sponsors or seek other visa pathways. And so the minister made this good news announcement on the 5th of June speech. In addition, we have made further decisions to better encourage people to speak up and leave an exploitative employer. People working on temporary skills shortage visas will have 6 months instead of 60 days to be without an employer. During this period, they will have full work rights. Well, it may not be the 12 months visa I called for, but it's a great first step.
Thank you, Andrew.
This rule will give immediate relief and breathing space for people to move on and away from workplace environments they no longer feel comfortable in.
Janie, today I quit my job. And then I told my boss to...
Also, if they are unfortunate to lose their employment, this extra time will assist them to reassess the situation and perhaps a chance to find a new employer sponsor. To further encourage people to speak out against exploitation, Mr. Giles proposes to dump the current law penalising those who breach their visa conditions. For many people who have been exploited, the Migration Act essentially criminalises speaking out. Section 235 of the Migration Act creates a criminal offence to breach work-related visa condition. a penalty on the visa holder. One of the most important measures in our bill will be to repeal this. Well done, Minister. You've proven yourself in this role to be a person of good conscience and now using your position to make a difference. I can't tell you how long it's been since we've had a passionate minister at the helm. Perhaps this is the first one I've seen in my 24-year career. It seems since the Home Affairs Minister Claire O'Neill voiced her opinion that Australia's visa system was just too complicated, the media love to pick up stories where visa rules on people in Australia are resulting in some adverse situations. In this case, 3 overseas teachers on working holiday visas working in a rural school were forced to leave their teaching work to go to a farm if they wanted to obtain another working holiday visa.
Whereby the principal of Wodonga Secondary College made contact with me to tell me that at the time he was 11 teachers short. He had 3 Irish teachers working there, but under the visa that they were on, they were required to go and leave the school and spend their 88 days working in agriculture.
Well, as you say, Helen, we want to look after the agriculture sector, but surely we can chew gum and walk at the same time. We can have trained teachers teaching, which is what their expertise is, and we can have other, visa holders who've come here to work and to travel to do the working agriculture. You shouldn't force someone out of a job like teaching, surely, to go and do something where we can find others.
Well, here's the rub, really, Steve, is that we have one of the most complicated visa systems in the world. There are multiple visa streams. It's extremely difficult for people to navigate where they should be on what visa. What we saw in Wodonga were teachers who were under a visa that really didn't allow them to maintain their teaching work. We need to simplify the visa situation in Australia. There are just hundreds of visas of all different types.
Well, I'm sorry, but I can't see what's so complicated about these circumstances. The government could easily add to the working holiday visa rules to allow other specific work which could be done to meet these 2nd and 3rd working holiday visa schemes. That work could be aged or disability care, healthcare work, or indeed teaching. But at the moment, that has not taken place. Teachers who applied for their working holiday visas knew about the agricultural work conditions they needed to do to get the subsequent working holiday visas, and they agreed to that scheme. If the school really wanted them so much to work there, they could sponsor them for the 482 working visa. Nothing really complicated at all. And yes, whilst there may be many visas in the system, usually 2 or 3 suit particular circumstances like the one described here. It's not as if you need to understand the other 100 or so subclasses. Our visa system uses a regulatory law-based order. It makes the system fair and accountable. And believe me, the Immigration Department needs to be held account to sometimes. And the law and the courts are the only way to make sure the department does not get too powerful and trample on people's rights. Well, that's enough for me rambling for 1 week. Stay tuned to our next riveting edition, and I hope all those in Australia are enjoying their long weekend. Keep those subscriptions happening to support this channel, and a big thank you so much to all of you. As always, take care out there, and I'll see you next time. So bye for now.